2007 and 2015, and government of Cross River State. My Lord, parties are all absent.
Appearance.
May it please, my Lord.
Yes.
R.A. Manga. My Lord, I appear for all the claimants.
Okay. Okay, go and get my biro from the office. Get me biro. Yes, any other appearance? Any other appearance?
With respect, my Lord.
Yes.
We are not hearing you, sir.
Appearance.
We are not hearing you, sir.
Appearance, it should be from your own side. I'm hearing you very well and clear.
Well, sir, let us announce appearance, but we are not hearing the court. If it pleases my Lord, my name is Emmanuel Udo.
Emmanuel Udo.
Yes, sir.
Are you
My
appearing
Lord,
for who?
I appear with my learned friend, Dr. Lionel Efium. Lionel is spelled Lionel. Lionel Efium.
Yes. Yes.
My Lord, we appear for the claimant applicants.
You are appearing for claimant.
Claimant applicants, sir.
When we have already, did you listen to the case we called?
Very sorry, sir, we are not hearing.
There should be no confusion. The case that was called is NICN/CA/48/2019. Are you in that matter? Hello, counsel, are you hearing me? Hello?
Hello, we are sorry, we are not hearing. We are not hearing.
Then something is wrong on your side. If you are not hearing me, something is wrong on your side. The case that was called is NICN/CA/48/2019. Is that the case you are in, which is between Sir Brian O. Okfong and others versus the government of Cross River State? Counsel, are you hearing?
We are not hearing, sir.
How did you hear? I said, are you hearing? If you are not hearing.
Hello.
Mr.
My Lord, we are
Manga.
not hearing. But...
Okay, Mr. Manga. If you are not hearing, can you come to the court? Counsel. Counsel. Hello, counsel. Iban R.A. Manga that announced appearance, he has disappeared from the screen. I'm sure the council must be having problem with his own connection. Registrar, how do we call them if they let them come to the court? I will stand down. Let them come to the court. I will stand down, let them come to the court. Can you call? I don't know if he is. I'm sure he must be in your case, Mr. Obiji. It's not his case that we call.
Yes.
So I'm surprised he announced appearance. It's not his case we call. And now the problem I have, even the claimant counsel that announced appearance, he has disappeared. Mr. R.A. Manga that announced appearance for the claimant. Versus,
Yes, my lord.
and why you disappeared? I'm not seeing you. You have to remain on the screen until the end of the proceedings.
Network issue. Where I am.
Okay.
My lord, I don't know whether the defendant has announced appearance because I discovered that the passcode that was sent to us, there's no zero in the, it is not complete.
Now, how can you say it's not complete?
Because
If it is not complete, how did you join? How were you able to join? If it is not complete, you won't be able to join.
Yes, my lord. This is what I want to. That's what I want to explain. You know, I have other codes for other cases which were sent to me, and so when I checked all, I discovered that zero it was missing in our own suit. This suit, that's the last zero in the passcode.
Okay.
And the defendant lawyer, the current defendant lawyer, called me and told me that the code was not sent to him. So I forwarded to him yesterday.
If you have the correct one, then you send it to him.
My lord, that's what I was actually trying to do.
This matter is for judgment. The judgment is ready to be read shortly.
I mean, because you need to tell me that's the problem we have. I'm not hearing. No. Second, you need to tell me.
Where is the registrar? I say you should call the second. Yeah, this man who announced appearance, the other case, that case that you have not called. Call them, tell them to come to the court. Or you go and meet Idigbe and let him call them and tell them to come to court now. Go and meet Idigbe and tell him to call them. I say he should call them, they should come to the court. I will stand down the matter. If they cannot, if they are placed where they are, there is no service. This is the judgment of the court. The claimant on 12th day of December 2019 took out a general form of complaint, statement of facts accompanied by witness statement on oath, list of witnesses, list of documents to be relied on at the trial, and photocopies of documents to be tendered as exhibits at the trial. By the amended complaint, and statement of facts filed on the 5th day of March 2021, the claimants praise the court for the following reliefs. They are, I have reproduced the reliefs, so I will not read the reliefs out. I have also captured the summary of the case of the parties, that of the claimant, and that of the defendant. So I will skip reading that one. Counsel will read when they get the hard copy. I have also captured the submissions of the defendant, the sole issue which he formulated, and the argument therein canvassed have been captured in the body of the judgment. I then proceeded to the claimant's address. I have captured the written address of the claimants. So I shall keep reading that one also. In concluding his submission, the claimant urges the court to grant its reliefs based on the evidence adduced before the court. I now go to the decision of the court. I have considered the processes filed by the parties, the evidence led, and the evidence led, the final written addresses, and oral submissions of counsel for the parties. It is clear from the sole issue formulated by each of the parties that the parties are at ad idem that the issue for determination in this suit boils down to the proof of the claimant claims. The defendants are of the view that the claimants have woefully failed to prove their case to be entitled to judgment as per their claim. For the claimants, they insisted that based on the evidence which they adduced before the court, they are entitled to be granted the relief being sought, as the evidence which they have adduced has neither been contradicted nor controverted by the defendant. Therefore, the court should grant their reliefs. What is certain is that in civil cases, the onus of proof, i.e. the general or initial burden of proof, lies on the claimant. He who asserts must prove the assertion. The evidential burden is not static or fixed on a claimant. This means that where the general burden in the sense of establishing his case has been discharged, the burden then shifts to the defendant to prove the assertion made in defense. At this stage, the state of the pleading determines where the burden of proof lies. Also, as the case progresses, it may become the duty of the defendant to call evidence in proof or rebuttal of some of particular points which may arise in the case. See the case of Osaworo versus Ezeruka. See also Adegoke versus Idigbe. See also OAA Cooperative Society versus NACB Limited. From the pleadings and evidence before the court, the main grounds of the claimants is that they serve the defendant, that is to say, government of Cross River State from 2007 to 2015 as chairmen, board members, and commissioners in the statutory boards and commissions of the defendant, and by virtue of the provisions of Cross River State Political, Public, and Judicial Office Remuneration Law number 12 of 2007, they are entitled to be paid furniture and severance packages, which despite appeal and demand, the defendant have failed and neglected to pay them their entitlement. The defendant in the defense denied the claimants ever having been its employee or having served the defendant as political office holder or in any capacity. By virtue of section 136, subsection 1 of the Evidence Act, the burden of proof as to particular facts lies on that person who wishes the court to believe in the existence of such facts, unless it is provided by any law that the proof of that fact shall lie on any particular person. Although the burden may shift from one side to the other in the course of the case, in the instant case, in proof of their claim of being appointed by the defendant as chairman and members of statutory boards and commission of the defendant, the claimants tendered Exhibit CA 1 to 24 in evidence. It is to be noted that these documents were tendered in evidence without objection. The claimants have also stated that the letters are composite containing the names of all members. A careful perusal of Exhibit CA 1 to 24 will show that there are letters of appointment to various positions and posts issued to some of the claimants by the government of Cross River State. I quite agree that the letters encapsulated in Exhibit CA 1 to 24 be letters of appointment issued by the government of Cross River State are without more prima facie evidence establishing that the persons to whom those letters Exhibit CA 1 to 24 were issued to were appointees of the defendant. Therefore, they have employment relationship with the defendant. Those claimants to whom Exhibit CA 1 to 24 were addressed to are well stated. Exhibit CA 1 to 24 is very clear and unambiguous respecting those to whom the letters were issued to. It is clear to me from the wordings of Exhibit CA 1 to 24 that the people mentioned in the body of the letters to whom the letters were not addressed to were mentioned to show the composition of the board or commission concerned, and not meant to serve as letters of appointment for those persons mentioned in the body of the letters. To this extent, it is my view that Exhibit CA 1 to 24 only goes to establish appointment for the persons to whom the letters were addressed to, and no more. This finding means that all those claimants who have not tendered letters of appointment have not proved their appointment with the defendant. This means that they are not employees as far as this court is concerned. They are not employees of the defendant as far as this court is concerned. This is because a party is under an obligation to place before the court all relevant materials before the court for his claim. See the case of INEC versus ACD. The claimants who have not tendered letters of appointment have failed in their duty of proof. See Section 132 and 136, subsection 1 of the Evidence Act, which provides that the burden in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side, and the burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence, unless it is provided by any law that the proof of that fact shall lie in any particular person. But the burden may, in the course of a case, be shifted from one side to the other. See Ominoju versus Abire. See also the case of Attorney General of the Federation versus Anue Bua. For the claimant to succeed in this case, they must be able to show that they are appointees of the defendant, and their appointment is one in which their remunerations and allowances are governed by the provisions of the Cross River State Political, Public, and Judicial Office Holders Remuneration Law number 12 of 2007. In view of my finding that only those to whom letters of appointment were issued to are appointees of the defendant, the consideration of this case will be in respect of 6th, 7th, 8th, 9th, 10th, 12th, 13th, 14th, 15th, 16th, 17th, 19th, 21st, 25th, 26th, 29th, 30th, 38th, 45, 46, 49, and 54th claimants, while the others who have not tendered their letters of appointment are not properly before the court. Who have their letters of appointment before the court? For the claimants that have no letters of appointment and no any other evidence to establish their employment relationship with the dependent, they are not entitled to any claim. More particularly when they have failed to appear to testify before the court as to their employment with the defendant. The evidence of CW1 insofar as it affects the claimants who have no letters of appointment is hearsay. The reason being that CW1, the only witness of the claimants, has under cross-examination stated that the claimants have different letters of appointment and different work schedule. With this evidence, CW1 is not in a position to give evidence regarding persons that have their own separate employment letters with the dependent. Coming back to the issue of proof, the claimant reliance on Exhibit CC, CD, and CE cannot assist their case. The reason being that those exhibits do not have evidential value. To start with Exhibit CC, it does not have evidential value in the sense that it is a document that is unsigned. As a document without an author, it is unknown in law, which has rendered it not having any evidential value. The law is right that unsigned document is worthless document that is not capable of proof of anything. See the case of Unwocho versus LM. See also Aiki versus Idou. See also Sarai versus Haruna. See also Global Soft and Design Industries Limited versus NAFDAC. See also the case of Udo and others versus Asian. Furthermore, Exhibit CC is a document prepared by the claimants for the purpose of this litigation. Therefore, by virtue of Section 83, subsection 3 of the Evidence Act, has no evidential value in the eyes of the law. This is because the provisions of this subsection of the Evidence Act referred to has excluded documents made in anticipation of litigation by a person personally interested in the result of the litigation. See the case of NSIT FMB versus Clifco Nigeria Limited. See also the case of UTC Nigeria Limited versus Lawal, where the Supreme Court defined a person interested as a person who has a personal interest, financial, material, or otherwise in the outcome of the proceedings. The claimants in this case have this kind of interest. Therefore, they are covered within the provision of Section 83, subsection 3. See also the case of Okechukwu versus INEC. Therefore, this document must be discountenanced for purpose of this document, for the purposes of this judgment, for lack of evidential value. For Exhibit CD, it is a recommendation to which approval is needed. The claimants having not produced the approval cannot rely on recommendation as to the approval recommendation, which was to the approving authority. As the approving authority is not in any way bound by the recommendation, the approving authority has discretion to either approve or not approve the recommendation. I have also noted that the recommendation in this document was meant for the governor of Cross River State. Then how how the claimants got the document in its original form and tendered it before the court is a mystery, and the claimants have not told the court how the document meant for the governor got to their hand. This also goes to show that the governor has not even seen the recommendation to enable him exercise his discretion to either approve or not approve. This also goes to establish that there was no approval given by the governor. Therefore, this document cannot have any evidential value to prove the claims of the claimant. For Exhibit CE is a photocopy of a letter written to the governor of Cross River State on payment of severance allowance and no more. It cannot serve as proof of the claims of the claimant. It is also clear from the document that the amount being demanded in the letter is different from the amount the claimants are claiming before the court. Having shown that the Exhibit CC, CD, and CE lacked evidential value, we are left only with Exhibit CA 1 to 24 and CB. The question that readily comes to mind is, can Exhibit CA 1 to 24 and CB capable of proving the claim of the claimants? To be able to answer this further, an inquiry has to be made as to whether the claimants are such officers that are eligible to or entitled to make claim under the provisions of Cross River State Political, Public, and Judicial Office Holders Remuneration Law number 12 of 2007. This calls for interpretation of the relevant provisions of the law on the issue in question. By the canon of statutory interpretation, the primary purpose and object of interpretation of statutes by a court is to discover or find out from the words used therein the real intention of the legislature in making the provisions of the statute and the purpose it set out to achieve. The intention of the legislature is for enacting a statute, and the purpose for which the provisions are made lie in and can best be discovered by or through the express words and the language used in the provisions of the statute. In this context, in which they were employed or used, therefore, where the words of a statute are plain and unambiguous, the court's duty is to interpret the clear and unambiguous words, giving them their ordinary, natural, and plain meaning, except where such interpretation would lead to manifest absurdity or inconsistency with the rest of the statute, or where the context requires that some special or particular meaning be given to the words. In doing so, the court must not add or remove any words from therefrom, if the intention of the premise of the statute must be ascertained from no other source than the words used by them in couching the provisions, and it is there that their intention is entrenched. The words of a statute alone in such circumstances best declare the intention of the lawmakers. In this case, the claimants is predicated, the claims of the claimant the claims of the claimants are predicated on the provisions of the Cross River State Political, Public, and Judicial Office Holders Remuneration Law number 12 of 2007. The provisions of this law are plain, clear, unambiguous, and unequivocal. Additionally, there is nothing to show that giving the words their ordinary meaning would lead to manifest absurdity or inconsistency in the statute, or that the context requires that the word be given any special or peculiar meaning. See the case of Dankombo versus Abubakar. See also Tumsa versus Federal Republic of Nigeria. See also Stanbic IBTC Holding Limited versus Federal Road Safety Commission. It is also a basic principles of statutory interpretation that provisions of a statute ought not to be considered in isolation. In order to ascertain the true intention of the lawmakers, the provisions of the statute must be considered as a whole together with all other provisions of any other relevant statute. It is only by so doing that clear intention of the lawmakers will be revealed, thereby guiding against doing violence to the provisions of the statute on the subject under consideration. See the case of Obi versus INEC. See also Akpambo versus Okadibo. See also the case of Nobilis Ilendu versus INEC, and that of GCM Limited versus Travelers Palace Hotel. For the court to determine the entitlement or otherwise of the claims of the claimants, the court will be guided by the well-known principles of interpretation adumbrated above. By Section 1, of the Cross River State Political, Public and Judicial Office Holders Remuneration Law, number 12 of 2007, herein after referred to as the Law number 12 of 2007, payment of salaries, allowances, and fringe benefits for political, public, and judicial office holders in the state, with the effect from 1st day of February 2007, shall be made in accordance with the Law number 12 of 2007, as contained in the schedule to the law. The schedule has provided those officers of the state to benefit from the law. In item 3 of Schedule 1 of Schedule 1A, provisions have been made provisions of salaries for chairman, State Civil Service Commission, State Judicial Service Commission, State Independent Electoral Commission, Local Government Service Commissions, and other commissions as may be established by the Act of National Assembly were made. In item 4 of Schedule 1A, it has inter alia made provisions for payment of salaries of members of constitutional and statutory commissions and such other commissions as may be established by State House of Assembly. By item 4 and 5 of Schedule 11A, provisions for payment of 300% fixed allowance for furniture and severance grants were made for chairman and members of constitutional and statutory commissions in the state. For the claimants to be entitled to furniture and severance allowances, they must show to the court that they are chairmen and members of constitutional or statutory commissions established by the State House of Assembly. From the above exposition of the law, the onerous tax on the shoulders of the claimants is to satisfy the court that the law applies to them, to be able to see whether by the evidence adduced by the claimants before the court, the claimants qualifies to be among the beneficiaries of the Law number 12 of 2007. This court would look at the law number 12 of 2007, the law establishing the offices which the claimants occupies vis-a-vis the letter of appointment tendered before the court. By the letters of appointment of 6th, 7th, 8th, 9th, 10th, and 12th claimant, they were appointed as chairman and members of Local Government Service Commission. There is no difficulty for anyone to to find that these claimants are qualified and eligible to make claim pursuant to the law number 12 of 2007. This is because the law number 12 has in its schedule captured their offices as some of those to be paid salaries and allowances under the law. By law, these sets of claimants have their salaries, allowances, and their benefits unit, governor's office. I have conducted research on this category of claimants, but I am unable to lay my hand on any provisions in the Constitution or statute that establishing their offices in the Constitution or any statutory commission. Law established commission law established pursuant to the law made by the State House Assembly. This shows that these officers are not entitled or eligible to make or enjoy provisions made in the law number 12 of 2007 respecting payment of salaries, furniture, or severance allowances. This means the appointment of these claimants having not been under the Constitution or law establishing the statutory commission is not the type of appointment that can in law be taken, that can take benefit from the provisions of law number 12 of 2007. Under consideration, since the law number 12 of 2007 is not applicable to these claimants, their claim must fail and same is hereby dismissed. For the 19th claimant, he was appointed as director, administration / legal, and 21st claimant was appointed as director, rural road. These claimants are neither chairman nor members of constitutional or statutory commission established by a law enacted by the State House of Assembly. Therefore, they are not eligible to take benefit from or under the provisions of the law number 12 of 2007. These claimants have no rights to lay claim under the law number 12 of 2007. Their claim is not properly before the court and same is hereby dismissed for lacking in merit. It is to be noted that the position taken in respect of 19th and 21st claimant is notwithstanding the provisions in their letters of appointment stating that their remuneration, sitting allowance shall be as those applicable to full-time boards and commissions. This court cannot give effect to this provision because it will be contrary to and against the tenor of the spirit of the provisions of law number 12 of 2007, which had specifically enumerated those entitled to benefit from the provisions therein. Furthermore, there are provisions in the law enabling the governor to make appointment and to make appointees not covered by the law to take or enjoy benefit provided in the law number 12 of 2007. Directors are not covered by the law number 12 of 2007. Therefore, they are not entitled to any claim in this case. The 25th claimant was by the letter of appointment appointed as Director General, Border Communities Development Commission, while the 26th and 29th claimants were by their letters of appointment appointed as directors in the Border Communities Development Commission. The appointment of 25th, 26th, and 27th and 29th claimant were made pursuant to Section 8 of the Cross River State Border Development Commission law as amended from the provisions of Section 8, subsection 5 of the Cross River State Border Communities Development Commission law. The remuneration and conditions of service of the 25th claimant shall be the same as that of the permanent secretary in the state civil service in item 9. In item 5 of schedule 1 of schedule 1A of the law number 12 of 2007, a permanent secretary is one to present. Is one of the persons, permanent secretary is one of the persons enumerated as beneficiary of law number 12 of 2007. This means that the fifth claimant is eligible to make claim under the law number 712 of 2007 by item 5, schedule 2A of the law number 12 of 2007. A permanent secretary is entitled to 300% for furniture and 300% severance grant. For the 26th and 29th claimants, their entitlement as far as section 8 or section 5 of the border communities laws This means that 26th and 29th claimants are not entitled to make claim under the law number 12 of 2007. Their claims having not been properly before the court is hereby dismissed for lacking in merit. The 30th claimant, by his letter of appointment, was appointed Director General, Cross River State Electricity Agency. In the law number 12 of 2007, a Director General is not one of the persons to benefit from the provisions of the law number 12 of 2007. Therefore, the 30th claimant in this suit cannot in law make claim under the law number 12 of 2007. The letter of appointment has also not helped matters, as the remuneration of the 30th claimant shall be determined by the governor of the state. There is nothing before me to establish or show that the governor has determined the has determined the remuneration of the 30th claimant. The 30th claimant has no locus to make claim pursuant to the provisions of law number 12 of 2007, as is not enlisted among beneficiaries of the law. The claim of 30th claimant failed and same is hereby refused. The 38th claimant was by the letter of appointment exhibit CA 1 to 24 appointed as a member of State Secondary Education Board, though the 38th claimant is not one of the persons specified or provided for to benefit from the law number 12 of 2007. The provisions of section 20 of the Science and Technical Education Board juxtaposed with the content of letter of appointment of 38th claimant as member of the board. It will be correct to say that the governor, having been conferred with power to fix approved remuneration of 38th claimant, and the governor having approved the remuneration of payable in that respect, the 38th claimant is entitled to benefit from the law number 12 of 2007. Therefore, the 38th claimant is eligible to benefit from the law number 12 of 2007. The 45th claimant was by the letter of appointment appointed as chairman, Technical Education Board, while the 4th, 5th, 7th, and 8th claimants the appointment of these claimants were made pursuant to section 2 of the Science and Technical Board law. The law has conferred on the governor power to fix approved remuneration of these claimants. By his letter of appointment, the governor approves the remuneration and allowances applicable to full-time board and commission. For these the 49th claimant was appointed as chairman, Cross River State Transport Agency. The letter of appointment clearly in unambiguous terms stated that the remuneration allowances of 49th claimant shall be as provided in the law setting up the agency. By the Section 11 of the Cross River State Commercial Transport Regulatory and Monetary Agency law, salaries and allowances of 49th claimant shall be paid such salaries and allowances as are applicable in the public service. This means 49th claimant cannot lay claim under the provisions of law number 12 of 2007. And by so doing, his claim is based on gross misconception or law. Therefore, the claim of 49th claimant failed and same is hereby refused. For 54th claimant, his appointment for 54th claimant, his appointment as general manager was on salary grade level 18. Other allowances and entitlement are same with those similar to grade in the public service. It is clear from the letter of appointment that the 54th claimant appointment does not come within the appointment which the provisions of political, public, and judicial office holder remuneration law number 12 of 2007 applies. Therefore, the claim of the 54th claimant failed and same is hereby refused. From the foregoing analysis, having found that the 13th, 14th, 16th, 17th, 18th, 19th, 26, 29, 30, 49, 54 claimants are not covered by the provisions of Cross River State political, public, and judicial office remuneration, number 12 of 2007. We are left with the claim of only 6, 7, 8, 9, 10, 12, 38, 45, and 47, and 48 of the claimant's claim. The claimants in the pleadings and evidence before the court have stated that in line with the law number 12 of 2007, they are entitled to 300% of their basic salary, one payment for severance package for service rendered to the claimant. The claims of the claimants for severance, the claims of the claimants bordering on severance and punisher allowances being monetary in nature is a claim for special damages, which must be specifically pleaded and particularized, and also must be proved strictly with credible evidence, and without such proof, no special damage can be awarded. See the case of Joseph versus Abubakar. See also at AG Leventis Limited versus Akfu. See also Garba versus Kuje, Leventis Limited versus Akfu, Osuji versus was to be proved strictly with credible evidence, and without such proof, no special damages can be awarded. See the cases of Joseph Abubakar, AG Leventis Limited versus Akfu, Garba versus Kur, Otaru and Sons versus Iris. For the claimant to succeed in their claim, each of the claimant must prove to the satisfaction of the court entitlement he is entitled to the claim, as the court is not entitled to make its own estimation of the sum. It must be proved the claimants in this suit have not specifically and strictly proved the same as contended, as it is not the mentioning of items of special damage as did in this in proof of claim for allowances, which is mandatory, which is monetary in nature, and being claimed for special damages, the claimants must to prove two things: entitlement to the sum and how they came by the quantum of the sum. To prove an entitlement, the employee must refer the court to the exact provisions of the law, instrument, or document that compared the entitlement. See the case of Mohammed Dungus versus ENL Consortium Limited. And to prove the quantum of the sum claim, the rule regarding proof of special damages must be adhered to. This is because the claim for entitlement and or benefit, as in the instant case, being monetary in nature, is a claim for special damages. The law is that evidence ought to be laid before an the law is that evidence ought to be laid before an award for special damages is granted. And to succeed in a claim for special damages, it must be claimed specifically and proved strictly. The fact that it appears to be admitted does not relieve the party claiming it of the requirement of proof with compelling evidence. See the case of NNPC versus Clippo, Nigeria Limited. See also Mr. Ignatius Anyao and others versus Aloysius Uzuamaka. See also Christopher U. Inanji versus Postal Services Limited. Furthermore, the claimants in this case have a duty to give specific particulars of the special damages they are claiming. This is to enable the opposing party know what he is to meet in the case. See Attorney General of Anambra State versus CN Onuselogu Enterprises Limited and Maritime Management Association Incorporated and another versus National Maritime Authority 2012 LPLR. But in the by the decision in Mr. Joseph Akinola and others versus Lafarge Cement Work for Nigeria Limited. Specifically, the court cautions against the reliance on an oral contract as proof of such entitlement. In their quest to prove their case, the claimants tendered Exhibit CA 1 to 24 and Exhibit CB as proof of both their entitlement, how they came about the quantum of the claim. This exhibit cannot in any way prove the claims of the claimant. This is because in 7-Up Bottling Company Nigeria Limited versus Augustus is specific in holding that proof of special damages is strict and must be to the satisfaction of the court. For a claim for special damages to succeed, the claimant must prove the quantum being claimed. The claimants in this suit have not particularized the claims for severance allowances, though from the law number 12 of 2007, 300% of basic salary can be ascertained. The amount stated as annual salary for the claimants is not the actual amount the claimants were receiving as basic salary during the period they served the defendant by the provisions of Personal Income Tax Act. Allowances are taxable, and before payment of salary is effected, tax must be deducted from basic salary. Therefore, the basic salary as contained in law number 12 of 2007 is not the exact amount the claimants were receiving as their basic salary during the period they served the defendant. Tax is deducted before payment are effected to the claimants. The claimants made reference to law without stating the actual sums and proof of what they are actually entitled to and paid to them as basic salary after tax deduction. I shall reiterate here that by law, allowances are subject to tax deductions. The claimants have deliberately refused to tender their pay slips or statement of account showing the tax deductions and what they were actually collecting as basic salary after tax deduction. The refusal or neglect by the claimants to establish the exact amount being paid to them as basic salary after tax deduction means that the claimants have failed to strictly prove their claim before the court, as they fail to make available to the court relevant materials fact that will enable the court to do justice to the parties. In the circumstances, the claimants have failed to prove their case, same is hereby refused. The failure of proof of relief one means failure of all other reliefs in this case. This is because relief one is the main reliefs upon which other reliefs depend. They depend on grant of the first relief. The relief one having been refused, also the other reliefs must be refused for lacking merit. Same are hereby dismissed. Before concluding this judgment, I need to stress the point that the duty of counsel in filing claim before the court demands making effort to ensure relevant material facts are put forward before the court for the court to be able to justly determine dispute before it. This case is a classical example where the court is deprived of having relevant facts fit for determination of dispute. Facts are sacred, and the main things that the court applies to law is determined in law in determining dispute submitted before it for resolution. The case as put forward by the claimants is destitute of relevant facts to enable the court to determine the dispute between the parties. Therefore, the claimants have woefully failed to prove their case without God. Therefore, the claimants have woefully failed to prove their case with cogent, credible, relevant, and admissible evidence. In the circumstances, I have no choice than to dismiss the suit for lack of proof. This case is hereby dismissed. I make no order as to cause. Judgment is entered accordingly.
As court pleases.
As court pleases.
Thank you, my lord.
Yes.
Yes.
My Lord, we thank you for the judgment of the court.
Yes.
My Lord, we can now hear my Lord in suit number 18/2022, sir.
It has not been called.
Very well.
Yes, counsel, registrar. Call the next case.
My Lord, my Lord, may I take my leave?
Yes, you are free to go.
Thank you, my Lord.
My Lord, as was a ruling, sir.
Counsel, exercise patience. They will call you a case.
Very well, sir.
Registrar, call the next case.
Suit number NICN CA 13/2022 between Palmo Nigeria Limited and one registered trustee of International Association of Plantation Farmers Laborers. 2, Robert and Robert. 3, Anete B. Johnson. 4, Joseph Abad. 5, Ubon Christopher. 6, Naomi Sunday Basi. My Lord, the claimant is absent. Defendants are all present, my Lord.
Appearance.
My Lord, we
Appearance.
respect. My Lord, sir, we respect. My name is Emmanuel Udo.
Yes.
My Lord, I appear with my learned friend, Dr. Lionel Efium, for the claimant's applicants. Take it, sit in the other office.
Yes.
My Lord, my learned friend, Ogbuji usually appear for the defendant respondent.
Allow him to announce his appearance. Yes.
Okay.
Respectfully, my Lord,
Yes.
Chief Ogbuji. My Lord, my humble appearance is for the defendant's respondent. My Lord, we are surprised that the link that was sent to other police on the other side was sent to me. I don't understand why. I still thank Happy New Year, my Lord.
Thank you. This matter is for ruling. The ruling is ready to be read shortly. This is the ruling of the court. The claimant commenced this action via a general form of complaint dated the 19th day of April 2022 and filed at the same on the same day, claiming from the defendant as follows: A, an order of this court commanding the defendants and their cohorts to open the offices of the claimants' head administrative offices forthwith, situate at Plantation Headquarters, kilometer 15, Calabar Ecom Highway, Calabar Cross River State. B, an order stopping the defendants and their cohorts from further act of nuisance, interference, invasion of the head of administrative office of the claimant, intimidation, harassment, assault, and threat to life of management staff and other staff of the claimants, as well as business operation of the claimant's plantation at Inko, Ikot Okpora, and Sapele. C, perpetual injunction, restraining first to 6 defendants, their members, agent, cohort representatives, and howsoever they are called and described, from further locking the head administrative office of the claimant, situated at Plantation Headquarters, kilometer 15, Calabar Ikom Highway, Calabar Cross River State, as well as claimant's plantation at Ikot, Okpora, Inko, and Safele plantations. D, the sum of 240 million for illegal tapping of claimants' rubber trees, evacuating rubber lumps by the defendants and their cohort between January and March 2022, including illegal felling of rubber trees for firewoods and stealing of other claimants' assets. The claimant filed, along with the general form of complaint, a motion on notice brought pursuant to Order 17, Rule 1, Sub Rule 4A 5-6 of the National Industrial Code Civil Procedure Rules 2017, and under the inherent jurisdiction of the court, frame for 1, an order of interlocutory injunction restraining the respondent, their members, agent, cohort, representatives from further locking the gate of the offices of the claimant applicant situated at kilometer 15, Calabar Ikom Highway, Calabar Cross River State, pending the determination of the substantive suit. An order of interlocutory injunction restraining the defendant respondent from further act of nuisance, interference, intimidation, harassment, assault, threat to life of management staff of the claim highway Calabar, as well as the business operations of the claimant at the claimant's head administrative office situated at kilometer 15 Calabar Ikom Highway, Calabar, as well as claimant's plantation at Ikot Okpara, Inko, and Sepele, pending the determination of substantive suit, and for such further orders as this honorable court may deem fit to make in the circumstances of this case. The motion on notice is supported by a 23 paragraphs affidavit sworn to by one Ben Hita Etu, Commercial Director and Company Secretaries. In the affidavit in support, it was stated that due to dwindling fortunes of the claimant as a result of economic recession, the claimant could not meet regular payment of its workers' salaries, who are members of the first defendant respondent. Consequently, series of meetings were held with the defendant respondent on the ways and manner to source funds from the debtors and other sources of income to pay the outstanding workers' entitlement. The defendant, being leaders of local association, instigate their employees and adopted a resolution to put up resistance against claimant until their outstanding indebtedness is paid. See Exhibit 1. The defendant in furtherance of Exhibit 1 have been intermittently disrupting official functions, thereby discouraging investors who came in to turn around the financial fortune of the claimant. On 2nd day of January 2022, the defendants with their cohort locked up the head administrative office of the claimant situated at kilometer 15 Calabar Ikom Highway, Calabar, and threatened the management or staff of the claimant who will dare to come in with this serious bodily harm, assault, harassment, and intimidation. From January till date, the offices of the claimant have remained closed under lock and keys, stopping the claimants from carrying out its official business so as to raise money to pay the outstanding salary. The defendants have also felled rubber trees, steal rubber lumps of the claimant, thereby destroying the stock in trade of the claimant as well as the rest. The defendants have also gone to the rubber plantation of the claimant at Inko Ikot Okpara in Calabar, in Cross River State, and Safele in Delta State to destroy the claimant's trees. On the 22nd day of March 2022, a senior staff of the claimant by name Mr. John Joshua went to the head office of the claimant at kilometer 15 when he was assaulted, manhandled, and threatened by the defendants. The claimant in their affidavit undertakes to pay damages if this application turned out to be frivolous. Ata Ochinke Esquire, counsel for the claimant, in oral adumberation informed the court that he is relying on the depositions in the affidavit in support. Counsel also adopted the written address file along with the motion on notice as his argument. Counsel in canvassing argument submitted that it is an established principle of law before an application of this nature can be granted, certain factors must be established, which include legal right to be protected by this court, serious issues to be tried, pecuniary damages will not compensate claimant for injury caused, and that the balance of convenience is on the side of the claimant, and the undertaking to compensate the respondent if this should turn out to be frivolous. These principles are especially by virtue of Obeya Memorial Hospital versus Attorney General of the Federation have been established, and other plethora of authorities. Counsel contended the affidavit in support has shown that claimant has a legal right and substantial issue to be tried. In concluding his argument, counsel asked the court to grant this application. In reaction to the application for interlocutory injunction, the defendant respondent filed a 25 paragraphs joint counter affidavit in opposition. The joint counter affidavit was sworn to by Robert N. Robin, the second defendant respondent. The crux of the facts deposed to in the counter affidavit are that the non-payment of workers' salaries and other legitimate entitlement of the workers was deliberate, as can be seen from the several agreements reached, especially that of 29th day of January 2018, which predicated payment of workers' entitlement as i.e. salaries, pension, gratuity, and other allowances upon certain subheads, such as the sale of Sapele rubber operation, which sales improved the fortune of the company to the tune of over ₦1 billion. Yet workers' salaries and other allowances were never given any consideration till date. See Exhibit 001, and when payment is contemplated in Exhibit 001, never happened. Exhibit 002 was produced by the management. Though there have been several meetings held, but each time money comes, the claimant applicant will misappropriate and divert the money into personal use of the management staff. Aside from sale of Sapele rubber operation for over ₦1 billion, several other subheads have attracted money and brought in cash inflow to improve the fortune of the claimant, but all to no avail. This includes the sum of 202 million export processing grant by the federal government. Exhibit 002 was produced by the management The defendant respondent denied instigating workers. Rather, it was on the basis of their understanding and cooperation with the management that led to this prolonged indebtedness of workers, salaries, and allowances. The workers at a point saw the leadership as having compromised their position. Consequently, the workers immediately resolved that they can no longer listen to the leadership and decided to take their destinies into their hand. The workers have been owed salaries up to a duration of over 60 months now and unpaid allowances of over 10 years. The defendant respondent states that there have been no investors, as the issue of investors have always been a bait each time workers threaten to down tool. The payment of salaries and allowances have been predicated on sale of supply rubber organization as far as Exhibit 001 is concerned. When that was concluded, they now begin to predicating the payment upon sales of some hectares of land from Calabaraba plantation. This has also come and gone without any consideration given to workers' salaries, and now the issue of investors. See Exhibit 001, 002, and 003. There had been industrial arrest and disharmony since January 2002, resulting from the failure of the current management of the claimant to pay workers' salaries up to a duration of above 60 months, now and unpaid allowances of over 10 years. The workers down tool in line with the provisions of the law to have never prevented any management staff from continuing in his lawful duties. It is the management staff that for fear of all they have done, deliberately refusing to pay these poor workers, notwithstanding all the money that have accrued to the claimant within the period under review. Ogbiji Esquire counsel for the defendant's respondent in his oral submissions before the court relied on the deposition contained in the counter affidavit and also adopted the written address file as his argument. Counsel formulated a sole issue. Argument on the sole issue has been captured, so I will skip reading the argument. And now goes straight to the decision of the court. I have carefully and painstakingly considered the claimant's applicant's motion on notice for interlocutory injunction, the response of the respondents, the written and oral submissions of counsel for both parties. It is clear to me that what this court is to determine is whether, in view of the facts so far disclosed in the affidavit in support and the further and better affidavit, the claimant's applicant has made out a case for grant of an interlocutory injunction. The law is right that an order for interlocutory injunction is an equitable relief issued or granted by the court at the suit of a party complainant directed to the party defendant in the action or to a party that defends for that purposes, forbidding the latter to do so, to do some act, or to permit his servant and agent to do some act which he is threatening or attempting to commit, or restraining him in the continuance thereof, such act being unjust, inequitable, injurious to the claimant, and not such act as can be adequately redressed by an action in law. It is judicial process operating impersonal, requiring the person to whom it is directed to do or refrain from doing a particular thing. See Nigerian Telecommunications Limited versus ICIC Directory Publishers Limited. Interlocutory injunction is the injunction interlocutory injunction is granted in the course of pendency of litigation and lasts till final determination of the suit. It is granted to protect the rest in dispute at a time when the true owner is said to be ascertained, pending the determination of the dispute between the parties. By interlocutory injunction, the rest is preserved from being dissipated or frittered away until the substantive suit is decided. This means an order of interlocutory injunction guard, and protect the rest during the pendency of litigation. In Akibu versus Odutan, the object of interlocutory injunction is to protect the claimant against injury by violation of his right, which he could be adequately compensated in damages. In action, if the uncertainty were resolved in his favor, see Ekomachi versus Uku and a host of other cases cited therein. In an application for injunction in aid of claimant's alleged right, the court will usually wish to consider whether the case is so clear and free from objection or equitable grounds that it ought to interfere to preserve property without waiting for the right to be established. This depends on a variety of circumstances, and the Supreme Court has held that it is impossible to lay down any general rule on the subject by which the court ought in all cases to be regulated, but in no case will the court grant interlocutory injunction as a matter of course. See Diacatra Limited versus Omnia Nigeria Limited. See also Doing Pharmaceutical and Chemical Company Limited versus Benin Pharmaceutical and Cosmetics Limited. Generally, the most important factors the courts take into cognizance in granting an interlocutory injunction have been stated and restated in several decisions of the court. The cases have been captured in the body. They include Obeya Memorial, Kotoye versus CBN, Omeso versus Inebedon, Ezibilo versus Chinuba, and a host of other cases. The one thing that is well settled in law, however, is that grant or refusal of order of interlocutory injunction is the absolute discretion of the court, which discretion, like all other discretion, must be exercised judiciously, having regard to all the facts and circumstances of each and every case. It is always essential to remember that in an application for interlocutory injunction, a trial court the burden of proof on an application for interlocutory is entirely on the applicant, and he must discharge the burden in his affidavit. See Morofula versus Kwara State College of Technology. This does not, however, mean that the applicant has the legal duty to prove the merit of his case at interlocutory stage. It is in the light of the foregoing general principles of law, interlocutory injunction which govern grant or refusal of an order of interlocutory injunction that I shall consider and determine the application at hand against the background of the said principles of law on the facts. From the affidavit in support of the motion, on notice for interlocutory injunction, it is apparent that the main grounds of the claimant applicant centers on the alleged closure and evasion of the administrative headquarters of the claimant by the defendant, as well as intimidation, harassment, assault, threat to life, management staff of the claimant, and other staff of the claimant, as well as business operation of the claimant at claimant's plantation at Inko, Ikot Opala, and Sapele. The defendant respondent on their part, they stated that the genesis of the crisis with the claimant stems from the claimant's deliberate refusal to pay workers' salaries and other legitimate entitlement, despite several agreements reached, especially that of 20th day of January 2018, which predicated payment on sales of Sapele Roba operation, which sell As pointed out earlier, the law has been well grounded by a long line of decided authorities that an application seeking for an order, an applicant seeking for order for interlocutor injunction is calling for exercise of discretionary power of the court, which has to be exercised judicially and judiciously in line with the well-established principles governing such exercise. The court, in deciding whether or not to grant the order of interlocutor injunction, shall be guided by by nature of serious issues to be determined, balance of convenience and status quo as proper remedy. See OG versus Zaria Industries Limited and another. It is tried to know that an application for interlocutor injunction, the applicant must establish inter alia his legal right to bring the application. See Adesina versus Arowolo. The claimant in this case has stated that the defendants close its head office and are not allowed to access to staff of the claimant as on 23rd day of March 2022, one John, an IT staff, was deemed the response of the defendant is that they did not prevent any management staff from continuing his local duties. Rather, it is the management staff that become afraid to go to the head office for fear of all they have done by deliberately refusing to pay these poor workers, notwithstanding all the money that have accrued to the claimant within the period under review, as can be seen from exhibits 001, 002, 003 and 005 respectively. The remedy of an injunction, as the name implies, is temporary remedy to last till final determination of the suit. Being an equitable remedy, it is also discretionary. Hence, the central objective of the court is to protect the party applying for injunction against the injury by violation of his right, for which he could not adequately be compensated in damages or recoverable in the action if he in view of this, I am of the view that the balance of convenience tilt in favor of the claimant. If injunction is not granted, the claimant may continue to suffer irreparable damage by the closure and invasion of the head office. On this count, the application for an order injunction is appropriate in the circumstances of this case. To my mind, the injury the claimant will suffer would far outweigh the injury, if any, the defendant will suffer by the refusal of this application. In granting the application of the claimant applicant, I took into consideration the apprehension of the defendant respondent, as can be gathered from the evidence in the affidavit, in their counter affidavit, that the management of the claimant are making move to liquidate the claimant in order not to pay the defendant respondent their backlog of salaries of 60 months and 10 years allowances. In the circumstances, the grant of the interlocutory injunction has to be made on terms. For avoidance of doubt, the order of court is as follows: an order of interlocutory injunction restraining the defendant, respondent, their members, agent, representative from further locking of the gate of the claimant applicant situated at kilometer 15 Calabar, Ikom Highway, Calabar, Cross River State, pending the determination of the something suit is hereby granted. 2, an order of interlocutory injunction restraining the defendant respondent from further act of nuisance, interference, intimidation, harassment, assault, threat to life of management staff of the claimant, Highway, Calabar, as well as business operation of the claimant at the claimant's head administrative office situated at kilometer 15, Calabar, Ikom Highway, Calabar, as well as claimant's plantation at Ikot Opara, Inko, and Sapele, pending the determination of the substantive suit is hereby granted also. The claimant the claimant applicant is hereby restrained from liquidating its activities or selling its properties pending the hearing and determination of this suit. The ruling is entered accordingly.
As court pleases. My Lord, we are very grateful for the painstaking ruling. Thank you, sir.
Yeah. Yeah.
My Lord, we need to thank you for and especially my Lord for the additional student.
Yes. Then let me have date for
March 23.
no, this case I'm giving it priority.
Okay,
Let us give it accelerated hearing. Our counsel, Mr. Emmanuel Udo. Mr. Emmanuel Udo. I observe from the processes file when I'm writing the ruling that there is need for counsel to address the court on issue of jurisdiction.
My Lord, sorry,
Yes.
what is
I said after ongoing through the processes filed before me,
yes, sir.
there is need for counsel to address me on jurisdiction, whether I have jurisdiction to entertain this suit in view of the reliefs being sought.
Very well, sir. My
So
Lord, we will.
I will give you 7 days within which to file your address on that issue. Then upon serving it on the defendant, they will also have 7 days within which to file their own position concerning the jurisdiction of the court to entertain this matter.
Very well, sir. My Lord will do exactly that.
So let me record it.
My Lord, within 7 days, we will file an application to show that
Okay.
this court has jurisdiction to try this matter.
It's all right.
Very well, sir. We'll save same on the defendant.
It's all right. Counsel for the parties are to file written addresses on jurisdiction of the court to entertain this suit as it is presently constituted in view of the reliefs being sought by the claimant. In the circumstances, the claimant shall within 7 days from today file its address, while the defendants, upon being served with the claimant's address, shall within 7 days file their address on jurisdiction. This case is hereby adjourned to You said? Count I gave them 7 days. That is 14 days from today. Let's see which day will that end.
My Lord, it will end on the 8th day of February. 8th day of
see.
February.
Okay. This one, why did you say close?
My Lord is close. All matters that were supposed to come up on the 30th of November.
How many cases on this day?
Lord is much on his hearing.
Not all of them may go. So let's give them 21st.
Okay.
So this case is adjourned to 21st day of February 2023 for hearing on jurisdiction.
My Lord, we are
Yes.
very
February 21. February 21, 2023.
very well, sir. We are very grateful, sir.
You are welcome.
Thank you.
So we have come to the end of the virtual sitting. So you are free to go. The administrator, you can end the sitting, please.